In a perfect world, employees would never be harassed at work, and employers could completely forget about having protocols in place for running a harassment investigation. Add to that, many employers believe that because we are now in a post-COVID, often hybrid work environment, it should reduce or eliminate harassment claims. Unfortunately, that's not the case. Harassment claims have remained relatively consistent or have even increased in frequency since the onset of COVID. Conduct doesn't have to be in person to be harassment. We clearly don't live in a post-harassment world, and employers need to have a plan in place for how to handle harassment complaints or to investigate harassing behavior of which they otherwise receive notice. After all, in the realm of workplace investigations, if you fail to plan, you are often just planning to fail. My name is Alyssa Kranz. I'm a Florida employment lawyer, and today we're going to talk about the EEOC's recent guidance on workplace harassment investigations. Additionally, in this recent guidance, the EEOC emphasizes that employers faced with notice of a potentially harassing conduct are required to engage in what they say is a prompt and adequate investigation, and they must take reasonable corrective action to prevent any improper conduct from reoccurring. Now, this all sounds very nice, but there's certainly a lot of gray here. We're going to delve into the guidance through a series of questions to figure out and get some clarity. First, what does the EEOC consider a prompt investigation? A prompt investigation is conducted reasonably soon after the employee complains or the employer receives notice of possible harassment. That means you can't bury your head in the sand or assume there's no issue if you haven't received a complaint. As far as what prompt means, that depends on the specific circumstances, including the nature and severity of the alleged harassment and the reasons for delaying opening an investigation. The guidance has described an investigation opened one day after a complaint is made as prompt, no surprise, but explained that absent any mitigating factors, an employer that waits months after a complaint to open an investigation probably hasn't acted promptly. There's a lot of room for gray, but I would always err on the side of faster being better, and I would not want to play with how close I can get to the 2-month edge without falling off a cliff. Also, from a practical matter, an employer does not want to explain inaction when defending a charge or lawsuit alleging workplace harassment. Instead, let's get your ducks in a row and have prompt action in response to harassment concerns. That's going to put you in a better position to avoid or defend harassment claims. Second, what is an adequate investigation? The guidance explains this as an investigation that is thorough enough to arrive at a reasonably fair estimate of the truth. This doesn't necessarily require, a trial or something, but the investigation needs to be looked at by an impartial party, and it should seek information about the conduct from everyone involved in the party. The guidance illustrates with a situation where the employer did this incorrectly. In that situation, the investigator was a friend of a company supervisor. They were unfamiliar with federal anti-discrimination laws, and they had no experience conducting harassment investigations. Pretty clear cut. After some short interviews there, the investigator issued a single-page memo concluding without further explanation that there's no basis for harassment. Don't let your investigations fail in this same way. Investigations need to be designed to fairly and impartially determine what conduct occurred, whether it violated a company policy, and if so, what appropriate action should be taken. This means one size fits all does not work. It does not exist. You want to work with your employment counsel on the process for investigators so that they are properly trained and in the best position possible to use sound judgment under the specific circumstances. Third, what happens when you do your interviews and there's a mess of conflicting stories and he said, she said? That's not uncommon. Investigators then are going to have to make credibility determinations, something the guidance recognizes by emphasizing that whoever conducts an investigation needs to be well trained in not just the law, but also in skills for interviewing witnesses and evaluating credibility. In the previous version of the guidance, the EEOC provided a specific list of factors to help investigators weigh credibility. This list is not in the new version, and it's not really clear on how or why this choice was made. It could be because there's a lot of variety in how the factors are used or perceived. For example, in California, State agencies and some investigator organizations discourage demeanor evidence. This is one of the previous listed factors, as a reliable credibility factor. This highlights that it is important to stay on top of what applies to your particular business and the training provided to investigators. Multi-jurisdiction employers, this is where it can get tricky. Fourth, now that you've finished your investigation, how do you wrap it up? The guidance offers two statements about concluding an investigation. First, you're going to inform the involved parties of the determination. Where appropriate, you can tell them what action you are taking, but keep your privacy laws in mind. Also, informing the involved parties doesn't necessarily mean you should tell the complainant about the specific corrective action taken against the alleged harassers. I'd advise against that generally, but at a minimum, you should tell the complainant whether the investigation found their allegations substantiated or unsubstantiated. And again, if substantiated, that you will take appropriate action. Then you want to retain your records. This can help you improve preventative measures, including training or making credibility assessments, and it can help you in taking disciplinary measures. Also, these can be used as a defense to a charge or lawsuit. The best way to prove that you acted promptly and appropriately in the face of a harassment complaint is often to produce the investigation file and report. Should you have any questions on workplace investigations or want help reviewing your process, training your internal investigators, or assisting with other workplace investigation needs, feel free to reach out to your employment attorney, myself, or any Fisher Phillips attorney. Have a great day.